In this video, I'm going to cover with regard to the importance of conciliation and the role of the conciliator and how this conciliation has been used as a effective means for settlement of disputes under the Industrial Dispute Act of 1947, under the Family Courts Act of 1984, under the Hindu Marriage Act of 1955, under the provisions regarding conciliation under the CPC 1908. So, before going to these enactments, let us see what is meant by conciliation. Here, with regard to the conciliation, there is a great what you call the reference is there. So, as you know that there is the model rules are there with regard to the arbitration and conciliation. That means here these model rules has been framed by the United Nations Commission on International Trade Law. That means this United Nations Commission on International Trade Law, which has been started in the year 1966 under the Geneva Assembly, as a organization which can frame the rules for the harmonious settlement of disputes which is of the international in nature. So India is also following the unilateral model law of 1988. So here this the model rules, on the basis of this model rules only, the Arbitration and Conciliation Act of 1996 has came into being. So here under this enactment, we can see some of the aspects concerning conciliation with regard to the meaning of conciliation. Here it has been said that the settling of the dispute without litigation, and conciliation is a process by which discussion between parties is kept going through the participation of a conciliator. Here the role of the conciliator is very much important. Even though he is a neutral person, his role is very much important in nature, because he has to settle the disputes amicably. Here his main concern is to reach an amicable settlement of the dispute. That means he should be of he should be of the such a great quality. He should have the such great qualities. Being a conciliator, he should have the great qualities as a conciliator. That means he should have the quality of maintaining the fairness and justice, and he should have the quality of having the confidentiality, and he should be independent, and he should not be partial with regard to the parties, and he should be very much prompt in disclosure of information with the parties, and he has to follow certain legal formalities also, and he should have the ability to convert dispute as the settlement. So that's why this the conciliation process, it is of the voluntary. It can be called as it is a voluntary, confidential, and private in nature in settlement of the dispute. It should be such of nature that there should not be any appeal. There should not be any appeal. So that's why the principles of the conciliation can be discussed in the length that it is a voluntary nature of proceedings, and it is a flexible in nature, it is a speedy in nature, and it should be inexpensive, and the decisions are only recommendatory in nature. So here we are discussing with regard to the conciliation which has been started in the era of the settlement of disputes. That means it has grown that it is one of the form of alternative dispute resolution system. So here this arbitration and conciliation both are the playing a vital role in settlement of the disputes. Here the comparable difference between the arbitration and conciliation is that here arbitration is a dispute. Here their settlement process in which the impartial third party is appointed to study the dispute and hear both the parties to arrive at a conclusion. Whereas a conciliation is a method of resolving dispute when independent person helps to parties to arrive at the negotiated settlement. So that is the major difference between the arbitrator and the conciliator. So here let us see what are all the aspects concerning to the conciliation. Here the role of conciliator also is of such a great in nature, because here the conciliator, he will not act as a what you call just, he cannot act that he should receive the disputes. He can remain neutral with regard to the settlement of the disputes. So his role is very much important in nature. Here, when it appears to the conciliator that there exist elements of settlement likely to be accepted by the parties, he has to formulate the terms of possible settlement and submit to the parties his observation. So, after receiving the observation of the parties, the conciliator may reformulate the terms of a possible settlement in the light of such observations. Here, if the parties reach agreement on the settlement of a dispute, a written settlement agreement will be drawn by him and signed by the parties in drawing up the settlement of the dispute. So here, in this course, the conciliator may held some meetings with the parties and he has to draw up the settlement agreement by him in secrecy, and he may send it to the court as the case may prescribe. So that is the aspect, that is the role of the conciliator. That means the main role of the conciliator is to assist the parties to reach an amicable settlement of the dispute. So he may at any stage of the conciliation proceedings make proposal for the settlement of the dispute, and such proposal need not be in writing. You have to remember this one, and which need not be accompanied by any statement of reasons also. Here, each party on his own initiative or at the invitation of the conciliator, he may submit to the conciliator the suggestions for the settlement of the disputes. So these are all the what you call certain aspects with regard to the role of the conciliator. Let us go to the conciliation under the various acts. Here the probable questions will be like this: discuss the conciliation procedure under the Industrial Dispute Act, and discuss the conciliation under the Family Courts Act of 1984, discuss the conciliation under the Hindu Marriage Act of 1955, discuss the provisions regarding conciliation under CPC 1908. Here, until the amendment of 1999, there was no provision under the Civil Procedure Code with regard to the alternative dispute resolution system. Here, after the amendment which has been done in the year 1999, section 89 has been added. So here, with regard to the section 89, the disputes it may be settled either way of conciliation, arbitration, or mediation, or the judicial settlement. So that's why this even the civil disputes which can be harmoniously, which can be settled by the parties. So here this conciliation is proved to be a effective in settlement of disputes, because where we can find the independent and fairness and objectivity principle. Here the conciliator may propose certain aspects. So his role of is also very much important, because the main intention of the conciliator is to settle the disputes in the compatible way, and he can generate the options. He may forward the options before the parties. So the parties may take his options, or they can terminate the proceedings. So under section 76, they may not have to accept the proposals, but the role of the conciliator is very much of important in nature, whether it may be under CPC or it may be under the Industrial Dispute Act. The role of the conciliator is proved to be a very important nature. So here the conciliator, with regard to the conciliator, under the Indian Penal Code, under section 21, a conciliation officer seems to be is deemed to be a public servant. So he has got such a power, that means he can settle the disputes. He has got the commanding power. So, but even though he may not impose his decision as the arbitrator, that means in the conciliation procedure, a conciliator need not impose his decision. It is a totally a voluntary in nature. So what we can see in arbitration, here an arbitrator has the power to enforce his decision as required, whereas a conciliator do not have the power to enforce his decision. So there is no compulsory aspect in conciliation. So here, that's why this method of conciliation has been used under the different acts. So even because of you know that there are a huge number of filing of the cases in the court. There are the several years will take for the settlement of the disputes. So the saying is that means justice delayed is justice buried. So such things are there. So that's why this conciliation is proved to be a effective remedy in settlement of the disputes. So here this conciliation procedure has been used very effectively under the Industrial Dispute Act. So here under section 36 clause 1, workmen only to be represented. Here the Industrial Dispute Act, it expects that only workmen should be represented. That means limited number of workmen should be represented with regard to their cause, but no legal practitioners should be appointed to represent their family, what you call family affairs. That means family means it is with regard to industrial what you call the disputes, because the employer and employee, they will become they will become the family of one industry. So where the legal practitioners are not allowed to represent the cause of the workers, so they can represent their cause directly to the conciliator. So that is that aspect we can see under section 36 subclass 1. And here under section 10, the state government has got the power to refer any dispute to the Board of Conciliation. Here with regard to the industrial harmony, for the growth of the industry, for the peaceful the existence of the industry, here the disputes can be amicably settled by way of conciliation. So under section 10 of the Industrial Dispute Act, there is a reference with regard to the referring the disputes to the Board of Conciliation by the state government. So likewise under section 2 subclass C also, this the conciliation will attain the or it will attain the status of a statutory authority. That means when it attains the importance of the statutory authority, it has got the ways of settlement of disputes will be more effective. And under section 5 of the Industrial Dispute Act, there is a reference with regard to the composition of the board. That means who should be the chairman, how many members should be there, what are all their qualifications. With regard to all those things, under section 5 of the Industrial Dispute Act, the qualities, the qualifications of the chairman and the members has been mentioned. Likewise, what procedure has to be adopted while settling the disputes with regard to the employee and among the employee and employers. So the way of adopting of the dispute, the procedure is also very important. So here the role of the conciliator is very much it attains the very much the greater importance. So here we can see that the role the conciliator, he should have such a role that he has to see that dispute, he has to solve that disputes in the friendly nature, and he should have the complete knowledge about the rules and regulations, and he can conduct as many meetings as possible to solve the disputes. So that means these are all the qualities of a conciliator. That means he should have the ability to settle the disputes. That means he must have the ability to get along well with the employees or the workers, and he should know he should be in such a position, he should sense the pulse of the workers, so that he can so that the disputes can be easily settled out. So these things should be the prime concern of the conciliators. So under section 11, the procedure and powers of the conciliation officer has been mentioned under the Industrial Dispute Act. That means what sort of the procedure he has to follow, what are all the powers of the conciliation officer has been discussed under the section 13 of the section 11 of the Industrial Dispute Act. So likewise, with regard to the duties of the board, that is conciliation board, what are all the duties of the board? That means there is a mentioning with regard to the powers of the conciliation officer, there should be how they should they should settle disputes. Means first they have to investigate the actual cause for the dispute. That means investigate the same. Then they can go for the settlement of the dispute. That is, here the prime concern is to whether it is a domestic or it may be for the domestic, or it may be foreign commercial the dispute. The prime concern is to settle the dispute harmoniously. Then he come to know what is the exact what is the exact cause for the dispute. Then he can solve the dispute. So here it may be domestic or international dispute. So that is the main concern of the conciliator. That is under section 13 under the Industrial Dispute Act. The duties of the board is that they have to investigate the same and they have to settle the dispute. So this will come under the domestic the dispute. So likewise here, when this conciliation proceedings are going on, with regard to the industrial disputes, the workers should not resort to the strikes and lockouts. So they should not go for the strikes and lockouts until the completion of the conciliation proceedings. However, this I want to put that this the conciliation is proved to be a effective method in solving the industrial disputes. So Here we have seen with regard to the industrial disputes, and we have seen some of the aspects with regard to the civil procedure code. Let us see how the conciliation has been used under the family courts. Here, with regard to the family code, here what we have to see under the family court is that, so under family courts, probably you know that here the normally the disputes will be of between the matrimonial in nature. For the matrimonial remedy only, the parties will go to the family court. Here there are the disputes, the litigations. It may seems to be of trivial in nature. It has to be settled down. Otherwise, we don't find the smooth existence of the society. So that's why the litigation between the husband and wife is of such a nature that it should be, even though it seems to be a trivial, but it is at the cost of the existence of the society itself. So probably we can say that getting marriage itself is now very much difficult. The outside people, that is Swami Vivekananda has said that he has compared the marriage to the fort. That means outside people, they are very much eager to go inside the fort. They may go at one or the other day, but what about the people there? They are inside the fort. That means the inside people, they are trying to come outside the fort, but it's not possible. So that's why this this dispute is of such a nature. It may be what you call it is more dangerous than the dispute between the what you call two hated countries. I don't want to name any country. Here it is more dangerous than the what you call the vengeance between the two any countries. So that's why there are these matters, the litigation between the husband and wife. It has to be settled down very patiently under in a very confidential way. So that's why under 32A of CPC, there is a mentioning with regard to the in-camera proceedings. So there it has been provided with regard to the in-camera proceedings. So here under section 9 of the Family Court Act, the duty of the court is to first it has to persuade the parties to settle their disputes. So under section 2, the court itself has to adjourn the proceedings for the settlement. So probably you know here under courts the adjournments will not be given so easily. So under section 2 under the Family Courts Act, the court itself may ask for the parties, may adjourn the proceedings for the settlement, for the effective settlement, rather than proceeding with the case. So likewise, under section 6, there is an obligation on the state to fix the category of person as counselors. That means here there is also an obligation on the state, that is state government, to fix the qualifications of the counselors, those who can counsel the husband and wife effectively to settle their disputes amicably. So we can see how far this conciliation is proved to be very effective. So in this table I have not taken with regard to the juvenile justice system, where the children will be counseled effectively. So there is a greater mode is there, greater way of what you call counseling the children is there with regard to the from going into the what you call preparing them to be a good citizens. So here I am concentrating only with regard to the conciliation under the Industrial Dispute Act and the CPC under the Family Courts Act. Here with regard to the counseling, I have said with regard to the juvenile justice system. That means I have not said with regard to the conciliation. So next aspect is under the Hindu Marriage Act. So under Hindu Marriage Act, under section 23 sub plus 2, the court, before granting any relief, it has to before granting relief, it has to go for the conciliation first. And under section 22, there is a prohibition of publication in camera proceedings. So here, with regard to this one, there is a provision under the Hindu Marriage Act with regard to the prohibition of any publications by way of which has been taken place in the in-camera proceedings, and the court, before granting any relief to any party, its primemost concern is to see that the parties should go to the conciliation. So in today's video, we have seen that what is meant by conciliation. We have seen the role of conciliator, and we have seen the conciliation under the different enactments.